We got a special edition of Legal AF with Karen Friedman, Agnifilo, and Michael Popok, because we just went through and watched and heard about the sentencing of Donald Trump on the 34-count felony conviction. A jury returned 12-0, 6-month delay in sentencing, all because of Donald Trump. Last-minute reprieve by the Supreme Court denied. 5-4, with Amy Coney Barrett joining Justice Roberts to deny the blocking of the sentencing, and everybody showed up in court today for the sentencing. Josh Steinglass argued on behalf of the Manhattan DA's office. Todd Blanche argued on behalf of Donald Trump. And Donald Trump appeared virtually and gave a 5-minute rambling campaign speech. There's no far-ranging, doing everything except really addressing the issues that were in play during the sentencing. And as we expected, the sentence is exactly what not only Justice Merchan said it was going to be, but I will argue as we get through this hot take that the Justice Merchan, did something so smart and made his sentence almost Supreme Court proof, because he did an unconditional discharge, which, of course, our expert here, Karen Friedman, Agnifilo, criminal defense lawyer extraordinaire from the Manhattan DA's office for most of her career, is going to explain. Karen, why don't you catch everybody up now about what we know from what happened in the courtroom on these various participants, and then finally what Justice Merchan got around to saying before he imposed sentence.
Really, what the headline here that everybody's going to pick up on is that Trump was sentenced to what's called an unconditional discharge. This is what Judge Merchan said he was going to sentence him to, and really said his hands were tied because he is now the president-elect, and there's really no sentence at all, no conditions whatsoever that he can impose on somebody who's going to be the president of the United States, whether it be community service or probation or a fine or jail or anything. There's nothing, because he's a state court judge and this holds the highest office. He really felt like his hands were tied. And so he gave them an unconditional discharge, which some people will say is not even the equivalent of a slap on the wrist. It's truly nothing. But I would argue and push back that that's not true, that is not nothing, because a lot of momentous things have happened today. First of all, he is now officially a convicted felon, because he's not a convicted felon in New York until he is sentenced. And so today he has been sentenced, and so he will take office in 10 days as a convicted felon, the first ever in the history of this country. And so I think that's important. The other thing that's important is it just shows that nobody in this country is above the law, and that presidents truly aren't kings, because he's like anybody else. And that was the thing that really struck me about this proceeding that the parties talked about, which is, look, and the judge said this, look, the office of the presidency might be extraordinary, but the holder of the office is not. And when you enter this courtroom and you close the door, you are like anybody else. This trial was like any other trial. A defendant is like any other defendant. And it's the office of the presidency that's extraordinary, not the office holder. I thought that was what was really sobering, a sobering reminder of really the criminal justice system in this country. But there were a few other unusual things that happened today. First of all, Trump was permitted to appear virtually from Florida. That never happens. I can't think of another time, even during COVID, where a felon was permitted to appear virtually for their sentence, but they did. There was also a probation report, which I thought was really interesting. Now, we'll never get to see that. That's something that is not part of the public record. But what was interesting, a little nugget that the prosecutor, Josh Steinglass, dropped, was that Trump was actually interviewed by probation. There's a probation officer that conducted an interview like any other defendant, because this is part of the process. After you are convicted and before sentence, the probation officer will interview the defendant and take down all kinds of information and make a recommendation to the judge. And one of the things that they talk about is whether the defendant shows remorse. And of course, he showed no remorse and actually expressed that he thinks he's above the law, which we know, but it was just astounding to see that he is still saying it even after the sentence to a probation officer. So I thought a couple other things were notable. I thought it was interesting that Josh Steinglass, the lead prosecutor in this case, actually did the sentencing and not Alvin Bragg himself. It's because of the fear of retribution later that Kash Patel and Trump and others have talked about, that nobody's scared. Josh Steinglass was not cowering away from doing this sentencing himself and having the elected DA do it, just to kind of have some separation. So I thought that was great, that the Manhattan DA's office was just treating this case like any other case. They didn't do anything different or unusual. And Steinglass recommended the unconditional discharge because he said, although this case could have received prison time, and it happens that people receive prison time, and I would suspect that if he was not elected president, we would see a sentence of prison time here, given not only the seriousness of the conduct, but also Trump's conduct during the trial, that he was held in contempt multiple times, and that he just to this day has no remorse. He talked about that this was a decisive, unanimous jury verdict that must be respected. And he talked about the things that Trump has done post-sentencing to undermine the verdict, like criticizing the jury, et cetera. And it was reported that Trump, although he was on video, was shaking his head when Steinglass was saying all this, and the microphone was muted. So if he said anything, we were not going to hear it. But he was sitting there in front of an American flag with Todd Blanche from Florida during all this and listening to this. And Steinglass went on to say that there was no expression of remorse, that Trump had these unrelenting attacks that were unsubstantiated on the court, meaning when they say the court, it means the judge and the judge's employees, also on the prosecutors and the jury. And he tried to encourage others to reject the jury verdict. So he said that Trump's conduct constitutes a direct attack on the rule of law itself and on Judge Merchan. And he cited both Justice Merchan's statements in the past and in other writings, as well as Chief Justice Roberts. And I thought that was interesting because rather than making this personal about Josh Steinglass or the Manhattan DA's office, he's actually citing to Chief Justice Roberts from the Supreme Court and Justice Merchan, just sort of saying, look, other judges have also said this, and just deflecting it away from the Manhattan DA's office and showing that judges have said this about him. And Steinglass said, look, this defendant has caused enduring damage to the public perception of the criminal justice system, which is true. He really has. And that is what I think what I think is the issue here, is really how he's undermined the rule of law and undermined the criminal justice process, and basically said, look, the sentence of an unconditional discharge preserves the status of a convicted felon, and he can now appeal and go through all of the various avenues that he wants to appeal. What I thought was interesting is Steinglass does not appear to have mentioned the case at all, the facts of the case, the seriousness of the case, et cetera. He's just talking about the criminal justice system and the defendant's conduct. Now, that's unusual. Most of the time, when you were recommending any sentence, you talk about the case, you talk about the facts. Steinglass stayed away from that. Now, Todd Blanche, who is soon to be the number 2 at the Department of Justice, who is Trump's lawyer who tried this case, lost, but tried this case. He went next, which is how this goes, and said that he intends to appeal the verdict, that the majority of the American people also agree this case should not have been brought, and said it's a sad day for Trump and his family, and just made brief remarks. And then Trump was given an opportunity to speak, which he chose to take that opportunity. And as you said, it was like a campaign speech. And he said, this is a terrible experience. It was a setback for New York court system. But he also kind of, that he doesn't go after Bragg himself. He says Bragg didn't even want to bring this case. He thought it was inappropriately handled. But he's talking about a separate case that Bragg chose not to bring. So I think he's conflating and confusing these different cases. And because Bragg actually chose to bring this case. It was the other case that Cy Vance was investigating, and was Cy Vance being the prior DA who I worked for. who recommended charges to be brought, Alvin Bragg, when he took office, looked at those charges and declined to bring them. The subject of that was largely what was covered in the civil fraud case in front of Judge Engoron here in New York, and chose to bring this case instead. But it's interesting that in all of his ire, Trump doesn't seem to go after the DA, Alvin Bragg, but he said, look, this was... He did his campaign speech stuff. Oh, this was a legal expense. That's what it said. I didn't say it was concrete. I didn't say it was, construction. Is a legal expense, paying I guess he thinks paying a porn star hush money payments and then lying about it is a legal expense. But anyway, called it a political witch hunt, et cetera, et cetera. Now, Judge Marchand closes it out with his remarks, which is how the process goes. And he basically said that, thank you, Mr. Trump. Never before has this court had a case like this. This is truly extraordinary. But then he went on to say, but it's the office of the presidency that's extraordinary, not the occupant of the office. And that there's nothing different about this trial, that once the door's closed, you're a defendant like everybody else. And the jury is the jury, and the legal protections go where they go as they would to any other defendant. And he basically said he doesn't need to repeat the aggravating factors that he recently talked about in his recent orders, which he did very much in his recent orders where he talked about what the sentence is going to be. He said, however, there's so many legal protections that are afforded to the office of the presidency, not the person, but the office of the presidency, that literally overrides everything else in the sentencing. And so it does not reduce the seriousness of the crime or justify its commission in any way. These legal protections, but one power, I love this one power that these legal protections that the office of the presidency holds do not provide is the power to erase the jury verdict. So he sentenced him to an unconditional discharge and closed out his remarks saying, "Sir, I wish you Godspeed as you take your second term in office." It was about 40 minutes long, full amount of time any sentencing takes. And that was that.
It was a little bit anticlimactic, and I think the reason for it is everybody was being very circumspect because there's going to be appeals off of this. One of the reasons that Donald Trump has been losing all in 3 different courts, now 4 with the United States Supreme Court, about this case is because all of his attempts to stop the sentencing have been premature. In order to get full-blown appellate rights, in order to be able to appeal the merits, if he had any merits to arguing that Justice Marchand had committed reversible error, you got to get to the final judgment of decree, and you can't get there without the sentencing. So the first stop on the train 2 days ago, what I call the Manhattan Appellate Court, the first department, an emergency duty judge there said, no, I'm not stopping the sentencing. We need the sentencing in order for you to have a right to an appeal on all of the issues that you're raising. You're raising them prematurely. There's no such thing as president-elect immunity. So no, you're going to go forward. He didn't like that. So as we suspected, he went to the Court of Appeals, the highest court in New York, and the Court of Appeals said the same thing. Effectively, this record is incomplete. You can't start arguing about all the things you think Justice Marchand did wrong in the way he handled evidence or the application of the immunity decision. But we're beyond immunity decision. We're into every aspect of what is in front of Justice Marchand today is about pre-presidential conduct or while Donald Trump was never president. He was the acts he committed, the core conspiratorial acts with Michael Cohen. These are the people involved in the conspiracy who testified. Or as Donald Trump called him today, he's not George Washington. I don't know what that means, but we know he has a vendetta against our fellow friend and podcaster Michael. Michael Cohen testified. David Picard testified, the National Enquirer publisher. 2/3 of the conspiracy testified, along with dozens of other people and mountains of evidence against Donald Trump. So these couple of stray pieces of evidence that may or may not have touched on Donald Trump becoming president, that was really the only issue. There was never an issue because his lawyers already conceded that nothing about the conspiracy was covered by presidential immunity. They filed that in papers with Judge Alvin Hellerstein when they try to remove the case. This is what happens when you try so many different procedures. You don't know what you're doing and you're not consistent. They had already waived the issue. They already admitted that the conduct at the heart of the Stormy Daniels hush money cover-up affair was not covered by immunity. Okay, now we're left to these kind of arcane issues of evidence in immunity that he tried to take up to the Supreme Court. So Court of Appeals said no. And as we suspected, he tried to throw a Hail Mary pass, jump the tracks, and go to the United States Supreme Court. It was closer than I thought it was going to be. I've done a hot take on it. It was 5-4. It's what I thought. Amy Coney Barrett, who's become the centrist, right centrist, was able to get Roberts to join her with the what I call the Democratic wing of the Supreme Court, Ketanji Brown Jackson, Sotomayor, and Kagan, to form a 5-person block to effectively say, there's no such thing as presidential elect immunity. They didn't say that, but they didn't bite on that opportunity when John Sauer argued presidential elect immunity. Like, that's not a thing. That's one. Two, they saw it as a run-of-the-mill criminal prosecution that had not yet been completed without the sentencing. And if he had any issues, he needs to take it up on a full appeal, exhaust his appeal rights up on the state court level, get a full and complete record. And if there's any constitutional issues left over for the feds, take it back to the Supreme Court, but not now. And then thirdly, this is what I mentioned earlier in the hot take today. This is the Supreme Court proofing that I think Justice Merchan very smartly did. We were all up in arms. Nobody wants an unconditional discharge. Nobody wanted that, at least on this side of the aisle, this side of the microphone. But we knew that was coming from last Friday. And that is the thing that the Supreme Court the five that voted to not block the sentencing, hooked themselves into, which was, well, what's the big deal? Justice Merchan has already said he's not going to sentence you to prison. And so it's not going to improperly interfere with your presidential transition duties or your incoming president duties. So no. And see how they went for that. Now, I think that was bait that Justice Merchan put out, just like we'll talk later on, not today, on the weekend, and on other things about, I think, a tactical move that was made by the Department of Justice and the special counsel about the Mar-a-Lago report. It's very similar. I'll tie it together at another point. So Supreme Court proofed it. They got their 5th vote. And therefore, we did not have John Roberts doing what I thought he found to be unsavory, which is to touch the immunity third rail again and try to bail out Donald Trump, having taken so much understandable flack for what he did with the immunity decision that he wrote back in the summer. So then we come into, with that as a backdrop, knowing there's going to be appeals left and right, you had a very circumspect Josh Steinglass kind of playing the role of the sentencing judge, but not outlining everything that happened. Then you had Donald Trump doing that 5-minute campaign speech and a very sort of shrunken Todd Blanche, not saying much either, other than this is not an appropriate case to have been brought, turning it over to his client to talk about the very terrible experience he went through. Of course, nothing like what he had written on social media. I mean, Donald Trump is two-faced. He tells his MAGA supporters on social media, I'll play their little game. I'll go into this ridiculous sentencing if they're going to make me do it. Very interesting, though. He didn't slam the Supreme Court when they issued their ruling not to block the sentencing. He actually said he understood the decision and it was a good decision. He just thinks they were put in a difficult position. He's starting to curry favor with them. Besides the fact that he and Sam Alito had a phone call about something unrelated to the things up before the court related to Donald Trump. At least we're supposed to believe that. We have no readout of the phone call, so we don't really know. All I know is the same day he's filing emergency applications with the Supreme Court to bail him out of a criminal case, he's on the phone with Sam Alito having a chit-chat. Leave that for another day. So he certainly sees the Supreme Court as being a place where he's going to be spending a lot of time with this administration in the coming year, and didn't want to piss them off by crapping all over them. Very, very, very cunning decision by Donald Trump. So he's blasting Alvin Bragg and Merchan before he enters the virtual hearing room. But then when he's there, he doesn't do much to attack them. He sort of wants to go back to the theory that, Joe Biden was telling Alvin Bragg what to do and making him bring a prosecution that Alvin didn't even want to bring. Totally wrong. We know the life cycle of how Alvin Bragg got right with this case, how he got right with Michael Cohen, how he didn't originally want to take the case, how he had to be convinced of it over time. I'm sure in talking to Letitia James, who was trying the companion case on the civil fraud that went up, and she was able to get a $458 million response. There's a lot of interaction between Letitia James and professional respect between the two of them, Alvin Bragg and Letitia James. And Letitia put Michael Cohen through the paces first. It took him for a spin around the track as a witness. And I'm sure that also gave a lot of confidence to Alvin Bragg in putting Michael up successfully in front of the jury in that case. So now what happens? What happens is he's now been sentenced, which means he can now take his full-blown appeal. He knows he's not able to go skip a step and take it to the feds. So he's going to have to go Appellate Division, First Department, which already has a briefing schedule in place through Justice Gessmer. There's I think briefs are all due on the 21st after the inauguration, but that's really on the emergency application, which I have a feeling he's going to withdraw the Article 78 lawsuit that he filed against Mershon and against Alvin Bragg, and instead he's going to focus on the full-blown appeal about all the things he thinks Justice Mershon did wrong, and that he should have recused himself, and his daughter works in Democratic politics, and Judge Mershon donated $50 to Democratic causes, and whatever he's going to argue about that. He can argue it to the two levels of appeal in New York, and that'll likely be the end of the road for him, because I don't see a constitutional issue really arising on this. Maybe that last immunity evidence thing, but you can see that there may not be the votes for that at the United States Supreme Court. So all that's going on. That's the update. Karen, anything else that we missed in the sentencing update?
Yeah, look, one thing I just will say is, first of all, you overstated a little bit how much Judge Mershon donated to a Democratic. It wasn't $50. I think it was like 20. But anyway, that's not accurate.
Thank you for chastising me over there.
No, I'm just saying it was so little that
I know. Right.
The only thing is, it's so unusual to have the sentencing is about to be released, and the audio, we will get to hear it. That's unusual. That does not happen. And so it is literally everything about this case is been happening. They're bending over backwards to make sure that the American people get to have the truth. I think it also reined Trump in a little bit. I don't think his attacks were terrible during his remarks, because knowing that he can't go out and lie the way he did throughout this entire trial, saying that things, he would literally come out and give a speech and say something happened, and then we would listen to the transcripts, and it turns out he just lied. But there was such a delay that we weren't able to do that. So that'll be, I think this kept him a little bit under control, knowing that he was going to be in check. And so that audio is going to be available. It's 40-minute long sentencing if anyone wants to hear it. But essentially, this is what happened. I'm so happy to have done this with you, Popok, to close this case out that I've been doing with you and Ben together, just covering it from the
4 years
for years. But it's finally closed out, and that's just happy to do it with you.
Yeah, I appreciate that. You too. And I couldn't wait when I saw in our chain about who was going to be able and be free. Ben is still suffering the effects with his family of the fires. And so we wanted him on here as well. But there will be, following this, there will be a hot take that Ben or Brett will do, which will incorporate the audio. But we wanted to get this up to you really quickly. So on behalf of Legal AF, Karen Friedman Agnifilo, Michael Popok, Ben Meiselas, follow us on the full-length podcast. We do Wednesdays and Saturdays at 8 p.m. Eastern Time on YouTube recording and all of our audio podcast platforms. Got a new show coming up on Saturday. I think Ben and I are going to have a hard time figuring out what to cover in that 1 hour period. And then, of course, we've got the new Legal AF YouTube channel. We're going to hit 400,000 subscribers this weekend, only with your help. We're people-powered here, Legal AFers and Meidas Mighty. We appreciate you all until our next hot take. Michael Popok and Karen Friedman Agnifilo.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.